Good afternoon and welcome everyone who's joining us. My name is Olivia Johnson. I am an immigration partner here at Shoemaker, and it is my pleasure to be your moderator and co-speaker today for our webinar, Trumping Immigration, How to Attract, Vet, Retain Talent Under the New Administration. I would like to formally welcome the participants joining us today and introduce my co-speakers, Maria Ramos and Wilka Toppins. Maria is a partner in our Shoemaker's Tampa office with over 2 decades of experience navigating employment immigration. And Wilka is of counsel for our Charleston office with over 34 years experience in U.S. immigration law. As I said, my name is Olivia Johnson, and I have been practicing immigration law since 2014 in both business and family immigration. As a roadmap for today's webinar, Maria will first be discussing how to attract talent, including changes to available visas, employer compliance, and the new H-1B modernization rule. Wilka will then be discussing stricter vetting procedures and heightened security measures to expect globally. And I will be completing our conversation today with a discussion on best ways of retaining current employees and future talent. As everyone here probably already knows, President Trump has certainly fulfilled his promises of stricter and fast-acting immigration policy changes. And with the many areas of uncertainty in the immigration world, we certainly hope that today's presentation provides a deeper understanding of what to expect the next 4 years and how best to prepare for those 4 years. So just a few housekeeping measures before we get started. Everyone is muted. If you have questions throughout the presentation, please feel free to put them into the Q&A section. We will try our very best at the end. We have a little bit of time for Q&A discussion, and we will try to get to all of your questions. If you have a question during the presentation or after the presentation and feel like it hasn't been answered, please reach out to us. There will be a slide at the very end with our names and email addresses. Feel free to reach out to me, Wilka, or Maria, and we'd be happy to continue the discussion. So at this time, I will turn it over to Maria, who will start us off.
Hi, everyone. As Olivia mentioned, I'm a partner in our Tampa office, and we're going to start talking about employment-based immigration policies and where we are today. We've seen changes to the H-1B, L-1, and other employment visas, and we are expecting potentially tougher adjudication standards than we've had in the past. We're also expecting some issues with regards to labor condition applications and employer compliance. We'll discuss those in a minute, as well as challenges to expect for high-skilled professionals, executives, and multinational managers. And I think we'll also discuss issues about visa availability and wait times. I think Wilka will probably go more into that in her category regarding vetting. But let's start with changes to the H-1B that we have experienced coming from the Biden administration. At the end of the last quarter, the H-1B modernization rule was approved, and it went into effect in early January. This was prior to the Trump administration. One of the good things about the H-1B modernization rule was that under the previous administration, we had had a lot of RFEs with regards to what specialty occupation meant. And there's been a lifting of the fog, so to say, where the rule has given greater flexibility as to what a specialty occupation is. In the past, we were challenged several times when we were filing H-1B petitions when an employer would require multiple degrees. You know, if you had a software developer, the employer in their job posting could say, the posting requires computer science degree, information technology, or computer or management information systems. Now, USCIS would take us to task and they would say, the Occupational Outlook Handbook only says software engineering or computer science. Because your individual has an information technology degree, please tell us how they qualify for the visa. So we would have to literally go into the weeds, explaining what common degrees were, whether or not it was directly related to the job. But with the H-1B modernization rule, I suspect that this should be easier. It has gone into effect. What we don't know is whether or not the Trump administration will have a different adjudication standard than what the regulation, what we think the regulation says. Also, another thing under the H-1B modernization rule that we have is that now it has removed for startup businesses, the startup can actually sponsor the owner for an H-1B. That was something that previously was presented an issue for a lot of startup companies, that they weren't able to get H-1Bs. So I think you'll see some entrepreneurs exploring the H-1B category. The modernization rule also worked with the H-1B cap exemption changes. Instead of for research organizations, there was a set of visas set aside where if your research organization, the primary duty of the organization was to do research, they may potentially qualify for a camp exempt H-1B. They edited the definition to say not necessarily primary, but if research is fundamental or part of the organization, your organization may actually qualify to get cap exemption. A good thing, another good change with the modernization rule that we had was we can now have a longer cap gap for F1 students. As many of you know, for individuals who have OPT, if they are selected in the H1 lottery, they would get cap gap until September 30th, with the idea that the H1B would kick in on October 1st of the fiscal year. Well, that didn't always happen. We didn't always get the H-1B approval before October 1st. You saw a lot of employers have to use premium processing in order to get the H-1B or get people in on time before that October 1st. Well, under the modernization rule, it extended the cap gap to go through April 1st of the fiscal year of the lottery. So we have a longer time to get that H-1B approved than we previously did. Okay, next slide, please. And I think one more slide. Another thing that I didn't list on the slide that the modernization rule did was it also codified the case Simio. And I want to bring this up because I know personally we've had a lot of clients who've had this issue with the remote workers. So Simio was a case where an individual moved prior to filing an amendment of their H-1B petition. And immigration said, no, you cannot move until you have filed the petition at least. Petition does not need to be approved, but the filing of the petition has to come before the relocation of your employment. That is because under the H-1B scenario, the labor condition application, which is the document that you filed that accompanies your petition, where you are determining what the prevailing wage is, you set, and in that document, you specify the location of employment, because that's so important and integral to the H-1B scenario. Immigration said, no, that has to be done first. What we have discovered lately, especially when we're doing H-1B extensions, a lot of individuals move throughout COVID. Everybody knows everybody went remote and did this. What the problem has been, not all employees informed their employers. And to the extent that they did inform their employers, they might have told their direct managers, except their direct managers are not the people who speak to the immigration lawyers. Most of the time, immigration lawyers are in contact with HR. So if HR didn't know that someone moved, they didn't tell, hey, can you file an extension or amendment for this person so that you could file it prior to the relocation. So under the H-1B modernization rule, this has been codified that the law is that you have to file prior to the move or the relocation. Now back to the slide. I think it's regarding employer compliance. Now, one of the issues that we think under Trump that we're going to see is a greater emphasis. The whole talk has been tougher on immigration. Let's do things the right way. We have to follow the rule of law and all of that. What I think you're going to see is a stricter application of the law, meaning sometimes in some of those cases where the individuals moved prior to the filing of the petition, we would write an equitable argument to accompany our petition. There was some, it would be tough on the employee to have to go outside of the US to process at the embassy. They have ties, they have a US citizen child. It would be an economic impact for the employer to have to go through this without this key employee or sending them out of the country. So that would be part sometimes of those types of applications. I think in USCIS, currently under the regulations, has discretion. They can approve those applications even though you did something you weren't supposed to do. I think you're going to see a lot less of that. I think you're going to see tougher adjudication standards and a lot less application of non-pro-tunc, which is that equitable argument that I'm referencing. I also think under the modernization rule, it referenced that USCIS has the right to go and inspect, especially in remote worker situations, the location of employment to ensure that what you have listed on your petition or your labor condition application is true and correct. And this would mean that they would have the right, if the remote work is at home, they would have the right to go inspect the home as a place of work to ensure that you're complying with the labor condition application. So I think employers should expect that there might be site visits in the H-1B scenario. I think also in the L-1 scenario, especially for new companies who may not be registered in the VIBE system or not have a record with Dun & Bradstreet, I think you're going to see an increase of these types of audits or visits where USCIS is trying to determine whether or not fraud is occurring or you're in compliance with the regulations or what you have dictated in your petition. Next slide. Next slide. Issues that I think you should expect. Everybody has heard on the news about trying to be tough on Canada and Mexico with regards to tariffs and some of the goals of decreasing the importing of drugs into the US and cracking down on the border and all of that. And the president has mentioned multiple times, and it's been delayed right now for a month, that he would increase tariffs on Canada and Mexico. One thing to keep in mind, especially for our employers who use the TN visa, the TN visa is a visa for professionals. It's limited to 61 occupations that are listed in the appendix to the NAFTA treaty. It is also a visa that's available for Canadians and Mexicans. And it's also sometimes when someone does not get picked in the H-1B lottery, it's a great alternative for certain individuals. So if we do go into a tariff war or there's some sort of issue between Canada and Mexico, I suspect that there's a potential for TN visas to be affected. Whether that means they are restricted, whether that means that they will continue to be issued, that's a potential issue. That's a potential issue to keep in mind and to keep tabs on. Another issue that, and I think Wolka will touch more upon this later, but I have a lot of clients who are L1s and they are multinational managers. So an L1 visa, for those of you who don't know, is a visa when you have a company outside of the US and you're transferring that employer or that executive to the US to either open up an office or to take a position to run an office or someone who has specialized knowledge. So for L1s, I would suspect, under the previous administration, they were not a fan of the Ls. And during COVID, we saw a ban of Ls of multinational managers being able to come in So that is something to keep in mind. We won't know if some of these things will happen until further down the road. But people have been talking that potentially travel bans are something to be expected. Also under the last administration, there were lawsuits and challenges to OPT. OPT is a program that normally F1 students are on. It's called optional practical training. It's a great way for foreign students who come to the United States to get their degrees in the United States to, once they graduate, potentially go to work for an employer, and maybe that employer will sponsor them for an H-1B visa or for a green card or whatever it is. Now, previously, OPT was only for 12 months, but then they set out an exception for individuals who had a degree in the STEM field, which would be your science, technology, engineering, and math careers. And they extended OPT by 24 months, meaning they had additional time. Now that the H-1B is really a lottery, there's no guarantee you get picked. Individuals who have STEM degrees, they will get at least 3 bites at the apple because there's no guarantee that you get picked that first time. So the fact that OPT for those individuals can be up to, allow you to participate in at least 3 different H-1B lotteries is significant. But during the last administration, we saw a lot of challenges legally, a lot of union workers who were concerned that they were being replaced by individuals on OPT or field. So we don't know. I would suspect that there will be challenges again to OPT. And as well, I think that there might be challenges to the H-4 EAD. Again, for those of you who don't know what H-4 is, individuals who are on an H-1B are your primary beneficiary. A lot of spouses of H-1B holders have an H-4, and H-4 is the dependent visa for the H-1B. Technically, under the law, H-4s cannot work unless they have their own H-1B or their own alternative visa category. But under the law, there was a law written where it allowed that if the H-1B holder, the H-1B visa holder, had an approved I-140, which is the first step to getting an employment-based green card, then the H-4 spouse, qualified to get employment authorization. And it is a big deal because a lot of people on H-1B, their spouses are highly educated, but they may not have the option of getting an H-1B visa, because again, H-1B visa is subject to a lottery. But if their spouse was already in the green card process, the H-4 gave them the ability to work. And if you think about it, it's not easy for an H-1B. A lot of the fees for the H-1B have to be paid by the employer. So not only are you asking an employer, hey, sponsor me for a visa, but in addition to sponsoring me for a visa, you have to pay all the costs associated with the sponsorship of a visa. That's a difficult thing to do, which the H-4, again, is a great benefit for those people. They don't have to go and say, sponsor me for an H-1B, because they have the option of also working through the H-4 EAD. I think that's my last slide. I think now I'll turn it over to Wilka, who's going to talk about vetting and tougher standards.
Thank you, Maria. Hi, everyone. My name is Wilka Toppings, and I'm going to be addressing the extreme vetting executive order put in place by President Trump on January 20th this year. The name of the executive order does not say vetting. It's called Protecting the U.S. from Foreign Terrorists and Other National Security and Public Safety Threats. So under the guise of national security and terrorism, the Trump administration essentially has instituted what we call extreme visa and immigration vetting procedures. This is not new. We had this in the last administration. Olivia, Maria, and I lived through this, and many of our clients lived through this. I do think there are some significant changes this time around on version 2 of these extreme vetting. When a person is applying for a visa abroad at a U.S. consulate or embassy in their country of residence, either a visitor visa or an employment or investor visa, or really any type of immigration benefit, the executive has now ordered the Department of State, who is kind of the embassies and consulates around the world, to institute extreme, and by that they mean to the maximum degree, they use that language, vetting and tougher background searches and investigations before actually granting the visa. So there's going to be another layer of vetting. Also, the executive has ordered the federal agencies, and that includes the Department of State, includes DHS, Department of Homeland Security, as well as NIS, to within 60 days of the January 20th day, executive order date, to submit a report to the executive branch to President Trump about countries that they believe should have or be designated as security risk to the United States. They did this the last time around. Back then it was, they listed about 7 or 8 different countries. This time, I don't know what countries are going to be put back on that list. However, we'll know in short order on those countries. And what that means is that those foreign nationals that are nationals of those designated countries that, according to the agencies, the federal agencies, present a security risk in the United States, those foreign nationals in probability will be either banned from entering the U.S. or denied any visas, new visas, and possibly, and this is actually in the order, possibly removed from the United States, even though they are legally in the United States with the appropriate visa. Now, let's think about that as it affects employers. Many of my clients and our clients have employees legally in the country. Some of them have been on valid visas for quite a number of years. They're valid contributors to your organization. They're important people. Think of doctors, researchers, engineers, technicians, etc. And if those foreign nationals are nationals that were born in a country that is listed in this security risk designation list, then potentially that foreign national will not have that visa anymore, may be denied a renewal, entry, or potentially be removed from the United States just merely because they are national of that designated country. Now, that sounds pretty extreme, but that's what the order talks about. If you want to put the next slide, please. So again, this is a little bit of a summary. So we are going to be expecting, and I'm telling all the clients to expect increased wait times and delays in visa clearances across all U.S. embassies and consulates. However, for those designated countries, which we'll know in a couple of weeks, you can expect to have maximum vetting and possibly complete denials, right? So suspension of visas for those nationals. Now, all of this is done under the guise of national security. So that is sort of under the complete, I guess, exclusive jurisdiction of kindness of the executive branch. So there's little to no judicial review or judicial remedy or appeal rights if one of your employees is denied a visa or entry or suspended or removed from the United States merely because they are a national of that particular country. Now, the thing that also could impact us is, let's say the person is in the United States, and let's say that they are at risk for this extreme vetting. The extreme vetting will also apply to visa renewals that are done inside the United States through the USCIS, the Federal Immigration Agency. So it's not just the consulates that are going to be instituting the extreme vetting. and screening and all these horrible things, but also the internal, agencies are instructed to apply those stricter standards. If you want to put the next slide, please. So again, key changes, tougher background checks for all visa applicants on a global basis. This is everybody across the board. We fully anticipate new travel bans being in place regardless of residency or visa status. So, for example, we all remember the so-called Muslim ban in the previous administration. We expect that to be put back in place. We expect suspension of visas for those national of countries that are perceived to be at risk to the U.S. We expect increased scrutiny for foreign nationals already living in the U.S. That are doing visa renewals. And if these individuals or legal immigrants are perceived to be from countries of risk to the U.S., potential removal and monitoring. And the executive order specifically mentions monitoring. I don't know how they're going to do that, but they specifically mention monitoring. I think one of the areas that is most concerning to me as an immigration lawyer, and it should be, I think, of concern to all Americans, is the fact that the EO makes mention in great detail of the need to focus on assimilation and U.S. identity and founding principles, whatever that means. It is just those words, that phrase, is difficult to interpret that. It's openly subjective. So, however, they make a point of saying that if any foreign national wants to obtain a visa, enter the United States legally, or apply for any benefit of any kind, they will take into account assimilation into U.S. identity and founding principles. And I'll leave it at that. Everybody can make their own reach their own conclusions, what that means, but it worries me a lot because it is so subjective. What can employers do until we get more clarity, until we see what transpires, what comes up, what countries are on this designated list? And I know this may sound a little bit, I guess, I don't want to say hysterical, but a little bit, overwhelming at this point. But I'm telling all my employers to discourage international travel that is discretionary. So if you can just keep your foreign national employees, especially those countries that were designated in the last administration, I would keep those people inside the U.S. because I cannot guarantee that in 30 days, 45 days, 60 days, they'll be able to come back. I would instruct my foreign employees that are abroad to return to the U.S. until we get more clarity on what is going to happen. I would definitely plan for longer wait on visa applications at U.S. embassies. So, for example, something that could have taken a couple of weeks to get an appointment, now it may very well take 4 months, 5 months to get an appointment. So plan on that. Plan on increased scrutiny on visa applications, both inside the U.S. as well as outside the U.S. And I would definitely recommend for those companies that have a large body of foreign nationals, like L1 blanket companies that bring a lot of expats into the U.S., to work with immigration lawyers on all of their future visa applications. I know a lot of companies have in-house HR professionals or global mobility professionals that are quite proficient in managing these processes internally. But believe me, this is the time that it's going to get really tough. And I would advise these companies to seek immigration counsel to review all applicants, all benefit applications. We just don't know what we're going to be facing in 60 days. Now, we lived through this before. We did live through this, and we made it work. People continue to get visas. People continue to enter the U.S. People continue to make the renewal successfully. People continue to receive immigration benefits. But we lived back then in a more intense scrutiny, more, longer processing times than I've ever experienced before in my 30 plus years of career. I expect this to be a repeat of that experience in the previous administration. I don't expect it to be worse, but I expect it to be the same. Now, one last comment before I pass it on to Olivia is, as you all know, immigration is is affected by geopolitical events around the world. So if the U.S. gets into a trade war or some type of disagreement or whatever fight with any country in the world for unrelated reasons to immigration or even national security, then potentially the U.S. can retaliate by denying visas to those individuals from that country. We saw that happening recently with Colombia, where President Trump, when Colombia did not want to accept a couple of military flights of deportees back in their country, immediately President Trump, with I think one tweet, essentially instructed the Department of State to deny all visas to Colombian nationals and suspend every visa processing at the U.S. Embassy in Bogota. And of course, that was remedied fairly quickly when Colombia ended up agreeing to, of course, accept these flights. But that was an example of the power of the executive to affect immigration benefits and ultimately affect us as immigration lawyers, as employers that employ foreign nationals, even students, even universities that have students returning to school, even researchers and hospitals that depend on physicians and professional health, workers. Regardless of background, regardless of profession, regardless of employment status, it could be green card residents cannot come back if the U.S. decides to take retaliatory action. So think about that and be observant of trade wars happening and things like tariffs. Things like that could be retaliatory and affect immigration. So that's my last comments, and we're here for you. We're here to serve you and help you through these challenges. And I hope that we can work with you. I appreciate it. Thank you so much.
Thank you, Wilka. Also, just to add to the points that you just made on the consular processing, it'll be interesting to see how the Department of Government Efficiency and all of their initiatives to kind of go in, get people off of remote work, get them back into the office. What they did with USAID recently, we don't know how staffing is going to be affected. So that could also, attach to longer timelines, longer processing, adjudication, maybe have less officers. So it'll be interesting to see how that kind of affects consular processing as well in the Department of State. But now that we've discussed attracting employees and the available visas and vetting and the increased scrutiny that we will experience for the next 4 years, I'm now going to talk about how do we retain the talent that we already have and future talent that is coming to U.S. employers. So, and you can just go next slide. This is a quote from Benjamin Franklin that I love: an ounce of prevention is worth a pound of cure. I think this is a great theme for the next 4 years. As immigration attorneys, we've been used to in recent years being able to get by with basic eligibility, basic submissions, being able to have the options in the future to add supplementary materials to our packages or respond to simple RFEs. We are going into an absolute new phase. We're expecting really comprehensive RFEs, as Wilka and Maria both explained. And so to kind of prevent having to cure those RFEs and respond to those RFEs, I think we need to take a lot more action in prevention on the start of the actual submission and making sure that we have no faults and preparing strong visa applications to avoid the delays and the denials that we are anticipating. So how do we do that? How do we prepare stronger visa applications? And some of this is very, if you're an employer that actively petitions for foreign applicants or you're an immigration attorney yourself, comprehensive intake. So identifying the admissibility issues at the very start of the process. In the hiring phase, take an intake and see what an admissibility issues that you may be dealing with, that at the consular phase, when you get, your interview and you're preparing your client or your employee to go through the consular processing, that you already know what you should be prepared for, not just the beneficiary, but the dependents as well. A lot of people come over as a single employee, but oftentimes it's a family and you have your main beneficiary and then they have their spouse and their children. So they too have to go through that inadmissibility problems, and you have to identify those issues before they come over. And maybe it's, their daughter who's 15 years old that has something that you need to address. And being able to take that comprehensive intake ahead of time, I think prepares you best for what you need to file on their behalf. Whether that be a FOIA, the FOIAs are going to take longer, in my opinion. They're already taking longer than they did last year. If it's a passport renewal, so say their passport expires in 3 months and the interview's in 2 months, get them prepared to go ahead and get that passport renewal. A lot of the passport renewals are taking longer, even outside of the United States. And look over their eligibility outside of the employment visa that you're looking to apply for them or petition for them. So any eligibility that you may not have thought of, if you're typically filing H-1Bs, maybe a comprehensive intake will allow you to look at other options that maybe you weren't thinking about. And this goes also back to Wilka's point of, if you have a global mobility specialist that's used to filing the same visas for the company, this would be a good time to build a connection and a relationship with an immigration attorney that's able to look beyond just those typical visas that your employees may be utilizing. Also, integrity of documents. I always say, don't take your word for it. You always want to go to DOS document reciprocity. So on DOS's website, there is a web page for whether the document that your employee is providing is an actual document that DOS will utilize and approve within the consular interview. So they have a document reciprocity. If you have a marriage certificate, if you have a divorce decree, if you have a birth certificate that maybe looks like it's not the proper document, go onto that website and look at those documents and see what examples that they have and what government bodies for that particular country should be issuing those documents. Also, employer internal documentation. So integrity of the documents that you're maintaining about the company that you may need to submit to USCIS. Taking record of that and being able to look over all of your documents quarterly to make sure that if you were to file a petition that you have everything you need on your side, so that, you're just worrying about the employee's documents and eligibility. Filing early, I think this is kind of straightforward, and greater utilization of premium processing. I think if you have premium processing service available for the visa that you are petitioning for, you should be taking advantage of it. And early filing, I don't mean filing before you're eligible to submit it. I mean preparing to file the application or petition on the day that it becomes available. A lot of times there will be lag for document collection or biographic information. I think now is the time that we need to be really keen to getting all of that ready and prepared early and filing on the date that you're eligible to file. And that's also for timely extension of applications. If you have an employee that's on an EID that's expiring, don't wait till the last minute to apply for the extension. If there's a non-immigrant visa that they're on that you're worried about the extension application, make sure you stay on top of your HR department to get those filed properly and filed on the day that they're eligible to do so. Responding to RFEs. Obviously, we're going to see a greater increase in comprehensive RFEs. Even in the last year, before the Trump administration, I was seeing greater RFEs in certain visa categories. I would call them blanket RFEs, where it would basically be asking for evidence on every single eligibility category, even if that those documents and that evidence was already included in the original petition. So we already saw kind of an increase of that in certain EB2 categories. I saw it in EB3 categories as well. So if that happens, I think that there needs to be a greater understanding of what the RFE, what has already been encompassed in the original submission, and what you are actually going to have to include as supplementary evidence to respond to it. Because I think we're going to see a lot more of those blanket RFEs where they're asking for absolutely every eligibility category to include more evidence. So if you've already provided what you think meets the eligibility category, reiterating that, re-highlighting that, and putting that into, your RFE response. But I would also set the expectations with employees and your clients that those RFEs are going to be more frequent, and not to be so scared if you receive a blanket comprehensive RFE that is anticipated. Increased preparation for consular processing. I think there needs to be discussion well in advance of what is needed for the consular stage. A lot of times in my experience, there's a hold for a police clearance certificate, or somebody didn't know they needed the police clearance certificate for when they were 17, 18 years old. They only received it for the country that they're currently living in. So I think that goes back to that comprehensive intake and making sure that you know what you are preparing for document-wise and biographic information for a consular interview. And also, if you're going through adjustment at USCIS. So how do we adapt our business operations to comply with these evolving immigration requirements? We'll be navigating this new complex regulatory environment for quite a long time. I think there have been daily, weekly updates, obviously, but daily updates within the immigration world within the last 30 days. So I think it's really important to have a source of information that you can trust that can be updated frequently. I know at Shoemaker, we're going to be trying to get our client alerts out more frequently, responding to events as they're happening, and making sure that our employers know what the regulatory information is so that they are following that immediately. These announcements are going to come out more frequently. We know that Trump has other plans. There's been discussion that those plans may be implemented more in Q2 so that they can be data traced and be compared to previous quarters. So I think it's very important for you as an employer to get a hold of the information in a very convenient way, but information that you can trust about any sort of regulatory information coming out. So if that's getting on our email list or looking out for our client alerts or joining webinars in the future, I would highly suggest that. And then aligning employment goals with potential visa availability. So I think every employer right now should start looking at their 5-year, 10-year plan for who they need in terms of foreign employment. And I say this because I think aligning your employment goals is kind of a twofold process. One is preparing for the next steps of an immigration journey for the staff or talent that you have now. And then it's also making sure that you're setting up your business for talent that you need in the future. So what I mean by that is preparing for immigration journey of an EB1 potential employee that you have now. If you're trying to get them to qualify for the EB1 outstanding professor and researcher category, what can you do now to encourage them to start meeting the criteria? Would that be encouraging them to write an article? Would that be encouraging them to participate on a panel? So prepping the talent that you have now, but also looking towards the future, if you need, a high volume of international talent and you don't have an affiliate company in another country that could maybe make you L1 eligible, what can you put in place now that you can, meet that goal within a certain amount of time and the needed time that you need for talent? Also, L1 blankets, if you're preparing for an L1 blanket, what are you doing to make sure that you're getting the amount of approvals needed to get that L1 blanket for the necessary year that you need it? So strategies for individuals to secure and maintain employment-based visas under these new policies. There is a lot of data if you care to go look at it and kind of compare previous quarters data against what we're going to see moving forward. And with that screening department data, you can go to USCIS. They have data on who's eligible for citizenship, how fast the processing times are going. You can look at your own case status and you can get all of those updates in real time. At DOS, there's visa statistics and obviously the visa bulletin that you should be very well aware of, but you can also look at previous visa bulletins and previous visa statistics to see how fast they are moving along, not only in the visa categories, but in how many visas that they are actually adjudicating each quarter. And then DOL performance status. So you're going to look at the data on PERMs. You're going to look at data on LCAs that have been recorded for H-1Bs, H-2As, prevailing wage data. So there's a lot out there, and I don't know what is going to happen under the Trump administration, if that data is going to be continued. I would expect it to be continued because they're going to want to have data to compare to their new regulatory rules and policies that they're putting into place. So I would expect that data to continue, but that is a great resource if you need to go look at some information from the past. Using the PERM as a retainer tool, if you have an employee that's on OPT, taking advantage, as Maria said, of that additional 24 months, file a PERM. Get it going so that perhaps, that might become current faster than them waiting for an H-1B pick in the lottery. So capitalizing on timeframes. And then dual intent visas, this will be something that we should all be watching for the F-1 to see how they, change any sort of policies for F-1 dual intent. But taking advantage of any dual intent for H-1B, H-4, L-1A, L-1B, taking, all the advantages that you can for those particular visas. So compliance and how to prepare for a raid and an audit. We obviously want to retain the talent that we do have, that we work so hard to get here. So what happens in the case of a raid or an audit? If you get anything from my portion of this presentation, it is to get an attorney-led internal audit. Many employers that have called me within the last few weeks concerned about a raid or an audit have said that they've done internal audits themselves on their I-9s. I think it is so important to get an attorney to look over these I-9s, not only to look at the documents that you've already saved and certified, but also to look at the processes that you have behind that. And if you have a third-party vendor that does your HR, this is now a reminder that they do not have attorney-client privilege. So that is also a gray area. If, they were issued a warrant, what would be, their rights and what they would need to do with the information at hand. So I think it's very, 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 very important that you reach out to an attorney, an immigration attorney, to lead an internal audit. If you don't want a full audit, at least provide a sampling so that we can look at that and make sure that you are not filing these and saving these and taking documents wrong for the I-9. Because if you're doing it wrong once, you're probably doing it wrong every single time you're looking over the I-9s. And same with public access files and PERM audit files. So written response plan, designated point of contact, have a plan in action, have a point of contact that's an attorney that can look over any warrants or subpoenas that may be issued to your business. If it's a warrant, I'm going to want to look at if it's judicial or administrative. If it's judicial, it's signed by a judge, but sometimes an immigration judge can sign it. That is still an administrative warrant. There are different plans of action for whether it's a judicial or administrative warrant. So you're going to want to have a designated point of contact in the business that is familiar with those two and knows what to send the attorney at what time. Have a plan in place and a person that knows the procedure of if an ICE team starts to raid the business. If it's a receptionist sitting at your front desk and 10 ICE guys come in and say that they have the right to enter the facility, they need to know about consent. They need to know about what to say. They need to be trained and make sure that they reach out to the point of contact within the company that knows the written response plan and can implement it. And then overlapping compliance issues. If, Trump has expanded raids to also include now churches, religious organizations, schools, hospitals. So there's overlapping compliance issues that we're dealing with there with HIPAA, with, private health information, with privacy in schools, with certain church procedures. So I think once you receive any sort of warrant or subpoena, you need to have a point of contact to get it to an attorney to make sure that that attorney is also reaching out to, your education law attorney or your health law attorney or white collar crime, and making sure that, everything is covered so that you're not consenting to something that you do not need to consent to. And then we do think it might be potential that they will make it mandatory for E-Verify. So keep a lookout for that. And if E-Verify does become mandatory, you're going to have to change your processes for how you accept the I-9s and making sure that your HR department is educated on the E-Verify process. And then obviously, if we're audited, if we get a notice of inspection, we want to make sure that we are prepared and can respond within the notice of inspection 3-day period. So having all of the I-9 documents saved and making sure you have, the procedures in place that, again, an attorney-led internal audit can guide you on. We want to make sure the results of that audit are compliance. So I think we're done with the attracting, the vetting, and being able to move forward and retain your employees. I think I'm going to open it up to Q&A. If anyone has any sort of questions about anything that we've discussed, please put it into the chat and we will try to address it. Okay, so I see, sorry if this was mentioned earlier, I may have missed it, but I'm wondering what would be the benefit of filing an EB-2 case with premium processing for a client already in the US? Since the visa bulletin isn't current, these clients wouldn't be able to adjust status anyway. It's a good question. I think, if the visa bulletin is 2 years behind, why are you asking for an approval, faster if we're going to have the same receipt date? So I think it's a case by case basis. And I think that's why you have to monitor the visa bulletin. I would say in that case, premium processing may not be worth it. However, you could utilize premium processing, and if you received an approval, at least you know that that is the approval and you have the opportunity in the designated amount of years on the visa bulletin to move ahead with it. So if anything, it eliminates the need to apply for maybe a different visa that they are eligible for that you're not worried about, and get in line for that visa as well. You already know that EB-2 is approved. So in terms of limiting, the time period, I don't think that would help you in that particular case. And it's a really great question. It's a thoughtful question because the receipt date doesn't change, but I think you never know how the visa bulletin is going to move along. And an approval is an approval. It's nice to have that and know that you've been approved. And then, it just eliminates other options. What do you ladies think? Would you agree? Do you think that's
I prefer premium processing. I want to know as soon as possible whether there are any flaws in the case, whether there's something we need to supplement and I don't want to wait 6 months down the road for some sort of issue to come up. So I know it's an additional expense. Doesn't always have to be paid by the employer, but I really prefer working with the premium processing service.
Yeah, and also I think the employees appreciate that. The uncertainty, it's very, very anxious, a lot of anxiety about whether they're going to get approved or not. So just giving that peace of mind to the employee, sometimes it's worth the expense.
We have another question, which is we have employees who are on H-1B and have already begun the green card process. Do you anticipate longer processing for the green cards as well? Yes. Currently, I want to say, if you're doing a labor cert, it's taking anywhere from 8 to 10 months to get a prevailing wage. It takes about 3 months to do your advertising. The last time I looked at the perm processing times for an H-1B, it's over 443 days for that perm to get certified. After the perm is certified, that's when you file your I-140, which you don't have to premium, but depending on the nationalities, I mean, there's lots of factors, but again, I prefer to premium process cases. You premium process your case, and then we have to see whether or not you're one of those backlog countries. Unfortunately, right now, we are backlogged for the entire world. Not as bad as India, which is unfortunately 12 years or so, or China, which is 5 or 6. But there are some countries that I used to be able to file green cards right away that are 2 years or 3 years backlogged. So, and keep in mind with the Department of Labor or any of those government agencies, if the government shuts down, Department of Labor shuts down and your case is not being processed. I mean, they pretty much, you can't even get on the website when there's a shutdown. So those are all factors that affect the timeline of how long cases take.
I want to add something real quick. President Trump has instituted a federal hiring freeze. In addition to that, this new, what is that? The Musk-led
Department of Government Efficiency.
Yeah, I forget.
Doge or Dodge or
Dodge, whatever. So they're trying to get rid of a lot of civil servants.
Mm-hmm.
So when you combine a federal hiring freeze and a purge, so to speak, of civil servants across all federal agencies, and a backlog system like we're currently experiencing, which is, in my experience, the worst I've seen in my career, I don't think it's going to get better. I think it's going to get worse. The only remedy that could happen is if Congress were to take action, comprehensive immigration action, and sort of institute some immigration reform and or increase visa quotas. Therefore, if they provide more visa numbers per category, then there's more opportunity for the backlog to be, move forward. Right now, the reason there's a backlog is because there's limited number of visas available per category per year. So they're used up quickly. There's more demand than supply of visa numbers. So if Congress were to get the act together and pass immigration reform, take into account the fact that there are a lot of qualified people, talented people that are working or currently working or trying to enter the workforce to contribute to our nation, that could go a long ways in alleviating the backlogs. But we'll have to see what happens. At this moment, I think it's only going to be worse.
I think it's also important to look at the data I know that, not a lot of people are looking at the data from past quarters, but the DOS, the DOL, the USCIS data that I included on the slide, it also shows how they're allocating that staff. So during Biden, we saw a little bit more staff on the N-400 side trying to get people naturalized. And when they do that, they're pulling staff from other departments. So even, at our local Charleston service center, I was asking the officer, do you work on N-400s every day? And he said, we used to work on N-400s on Fridays and Thursdays, and now we work on them, 4 days a week, and we do the other visas or other applications for AOS on the other days. So I think the allocation of where they're putting their resources is going to change as well, and that we'll see in the data for sure. So we have a final question, and I think this will be our last question. If anyone has any other questions after this, please feel free to email us. Our emails are on the slide. Do you think the USCIS officer's analysis changes when using premium processing? So In my opinion, it depends on the officer. There are certain premium processings that go really, really fast. I work a lot with EB2 NIW, and I find that the premium processing is sometimes a little bit more intense and more comprehensive RFEs. But I believe that's because they're a more intense visa, and the officers are also keeping up with how many premium processing applications are coming through and petitions are coming through. So if they have a high number, high volume, that they're dealing with, they may issue RFEs just to issue an RFE. But I do find that the approval rates of the returns of RFEs is very high. So that's just my experience. I would be interested to know Marie and Wilka's with that, but I do think that it depends on the officer, it depends on the visa, it depends on the petitioner application. And you may get an officer that had a really good cup of coffee and just feels really good about it, or you may get an officer that you're, the last petition of the day and they just don't feel like filling it out and they issue a more comprehensive RFE.
I think I see a lot of RFEs with L's, but in terms of, like you said, it's where they're giving you the kitchen sink. You've provided most of the information that they are requesting. So I always, with L, sometimes I see it on the 15th day instead of, I'm like, okay, they ran the clock on this one. They don't have time to decide in 15 days. So rather than give me my feedback, they're giving me an RFE.
Yeah, one last thing to one last comment. I've heard already that they're considering increasing the 15 business day premium processing turnaround to 45 days. So, some categories right now are 45 days, some categories are 15 days, it'll be 15 days forever. But they're considering extending that premium processing 45 days, which, better than I guess 6 months or 8 months or 12 months, but it's still much longer. So watch out for that.
Okay, well, I think that was the last question we're going to take today. This webinar is going to be recorded. If you need the recording, I believe it's going to be sent out. If not, please email me, Maria, or Wilka with any questions, or if you would like to get the recording link. We are so happy you joined us today. We're really hoping that, as we're expanding the immigration team here at Shoemaker, we're hoping to do more of these webinars. We're hoping to do more client alerts and respond very quickly to what is happening with the Trump administration. So please get on any sort of email lists, look out for our webinars, look out for our client alerts. We're going to try to keep you as updated as possible. And if there's anything that you have a lingering thought about after the webinar or thinking tomorrow, wait, that didn't make much sense, can they expand on that? Please, please, please reach out to us. So thank you so much for being here and spending an hour with us. I hope you feel a little bit more prepared and have a little more tools in your toolbox to take on the employment visas in the future.